Well, welcome everyone, and thank you so much for joining me. Hello, hello, hello. My name is Lior Samfiru. Yes, I'm the employment lawyer, and I'm here with you live for the next 30 minutes answering your questions about employment law. I'm one of the founding partners of Samfiru Tumarkin LLP. We practice law in Alberta, in Ontario, in British Columbia. So if you're in one of those areas, you want to know about your workplace rights, you're in the right place at the right time. All you need to do right now is ask a question, type it in, hit enter. I'll see it, I'll read it, and I will answer it. If you're wondering about wrongful dismissal, if you're wondering about constructive dismissal, human rights, discrimination, maybe your boss is not treating you properly, maybe your terms of employment have changed. Well, whatever the issue, whatever the problem, we can solve it. We can get it resolved right now, and you don't have to wonder anymore. So don't be bashful. Let's get those issues resolved so that you know what your rights are if you're facing a workplace situation. A good place to start right now. Now, beyond this 30-minute session, if you want to connect with me and my team, very easy to do that. That address is already here on the screen, employmentlawyer.ca. You want to connect with me and my team, you just go to employmentlawyer.ca. Phone number is there, email address is there. You'll see me refer to it again throughout the session today. But that's for after. Right now, I'm here live with you, answering your questions, wanting to make sure that when you turn off your computer, when you walk away from your screen, you know more than you did coming in. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And of course, I am here for you answering questions. So you can read, you can listen to me, but even better, get your questions answered. Be that second voice on this segment and make sure that you get those answers. I'm going to start answering questions right now. Ask yours as well. All right, first question today comes to us from Ocean Breeze. I wish I was at the ocean feeling the breeze. Is time and a half overtime based on your hourly rate, or is it based off of minimum wage? Great question. It's based on your hourly wage. So how do we calculate that? If you're an hourly employee, then you know what your hourly rate is. It's very easy. Time and a half, that is your overtime rate. If you're on a salary, in Ontario, overtime, for example, is paid over 44 hours a week. So whatever your weekly salary is, you divide that by 44, right? And then you get an hourly rate. And time and a half is your overtime rate. So that's how you do it. So no, it's not based off of minimum wage. It's based off of your actual hourly rate. And remember, overtime has to get paid if you work the overtime hours. Frankly, even if the company hasn't asked you to work it, they didn't necessarily approve it, but if you had to do it to get the job done, your employer has to pay for that overtime. They can't tell you, no, we don't want to, we didn't ask you. Overtime has to be paid. Hopefully that makes sense. Ocean Breeze, thank you for that question. You see how easy that is? Ocean Breeze had a question about overtime, got the answer. Now Ocean Breeze knows. Same with you. You can do the exact same thing. I'm going to continue answering questions, but if you're just joining me, Lior Samfiru, that's me, you can ask your question right now. This is your employment law session. All right. Next question from YouTube comes from Ace C's. I got sent home 2 weeks ago and was told when there are hours, they will call me. I was not officially terminated, never given a warning. The reason was because I refused to stop recording him. Okay, so here's the thing. If your employer tells you to stop recording and you don't, that is a form of misconduct, right? There's nothing wrong with recording, but there's something wrong not to do something that your employer is telling you to do. So if your employer says, I'm not going to talk to you if you're recording, and you continue recording, that could be cause for discipline. That does not mean you can be sent home without pay. So you potentially now can consider this layoff, whatever you want to call it, being sent home, as a constructive dismissal. All right. You can consider that potentially as a termination and require the company to pay you severance. If that is what you want to do, call the office. And let's connect and let's go ahead with that. Of course, to connect with me and my team, very easy to do. Employmentlawyer.ca is the way to do it. So don't hesitate to do that, and we can talk. Now, remember, of course, your employer generally does not have a right to just send you off work, to put you on a temporary layoff, to reduce pay, to stop paying you. If they do that, even though they may not have said that they've terminated your employment, in the eyes of the law, that's a constructive dismissal. You can't do that. All right, so ACs for you, those are the options. You can sit at home and see what happens, or you can choose to treat this as a termination of employment and get your severance. If you want your severance, connect with me through employmentlawyer.ca. Okay, excellent question, excellent questions. Same with you. If you have questions right now, what are you waiting for? Ask it. I'm going to continue answering all the questions that I'm getting right now. I'm going to get to yours, but don't wait. Let's ask that question now so that I can get to the answer before the session is over. All right, next question. RF has that question. I applied for a position within my company and I didn't get it. But for a half hour, my manager and assistant manager proceeded to tell me I didn't get it because I would not be supported by my coworkers because they don't see me as a helpful person and I'm too competitive. They then asked me who I don't like at work. I refused to answer and told them they can't ask that. Am I correct? Are they allowed to ask whom you don't like at work? Well, I don't think you're asking, are they allowed to ask? There's no law says, we're going to arrest you if you ask a question. The question you're asking is, do I have to tell them? No, you don't have to tell your employer who you don't like at work. No reason, and I probably wouldn't do that. There's no benefit. Now, if you think that the comments that they made about you are not correct, respond to it in writing. Say, you've told me that this is my behavior, but here's what you need to know about me. Or if you think there's a particular person that you think is picking on you, tell them that. Put that in writing so that they know, because you don't want that to be held against you in the future when you're trying to get a promotion or a different role. So if the company says things about you that you know are false or not accurate, put that in writing. Tell them why. Be respectful, of course, be professional, and put that in writing. But do you have to tell them who you don't like? No, of course not. You don't have to tell them that, and I wouldn't if I were you. Good question, RF. Thank you for that. I'm happy that you've asked that. Same with you at home. If you're just joining, I'm Lior Samfiru, the employment lawyer, here with you, answering your questions. Ask it right now. Let's make sure that you walk away with those answers. Okay, let's see. Continuing to answer questions from DXL on YouTube. Can my employer force me to relocate to a new facility? It's a little over an hour away and will make things much more difficult for me. So generally speaking, the hour is that threshold. And what I mean by that is if your commute now is going to increase by an hour or more, that could be a constructive dismissal. That move is a constructive dismissal. So it's not about how many kilometers away the company is going to relocate you. It's a question of how it's going to affect you, because they could be moving many kilometers away, but it actually could end up being closer to you. So that's not the issue. The issue is how many or how does that affect you? So if you're now going to be in a situation where it's going to be an hour or more to get to work in comparison to what it was before, you may be able to consider this relocation, this move, is a constructive dismissal. You can't physically stop the company from doing that, but what you can do is you can consider potentially this move as a termination of your employment and get your full severance. Now, if that's what you want to do, before you say anything to the company, before you say no or yes or maybe or I don't know, I want you to call my office. Let's have a discussion about that. Let's do that properly. To connect with me, employmentlawyer.ca is the way to go. That address is on the screen right here. Employmentlawyer.ca. Phone number is there, email address is there. Everything you need to connect with my team and myself is right there. Now, keep in mind, this concept of constructive dismissal, I've mentioned it already a couple of times today. That concept comes into play whenever the company does something that changes your job or changes your terms of employment or makes it difficult to continue working. So a regular dismissal, of course, is a situation where the company simply says, we're letting you go. A constructive dismissal is a situation where the company is not letting you go, but because of what they did, you, the employee, can choose to consider it, to look at it as a termination of employment and make them pay you severance. So that happens if your hours are cut or your pay is reduced, if you've been demoted, if your shifts change, if you're being relocated far away, like I was telling the individual before. So you name it, in those types of situations where the company does something that makes it difficult for you, that could be a constructive dismissal. Remember, with a constructive dismissal, you have to act pretty quickly. You can't say, well, you reduced my pay 6 months ago, now I'm saying constructive dismissal. No, by then you're going to be considered to have accepted what the company did. So there's only a very short window to deal with the constructive dismissal. So if you think the company did something to you that could be a constructive dismissal, call me or email me right away, okay? And to do that, of course, I said that, employmentlawyer.ca right there, employmentlawyer.ca. All right, I am going to continue answering questions. Please ask yours right now. Plenty of time still. I'm going to get to all of them. Next question on YouTube from Sir S. If your employer is supposed to investigate claims of a toxic or abusive work environment, how does that go? What should you expect, and is there anything you can do to protect yourself? So if the company becomes aware of workplace harassment or an abusive work environment, they have the obligation to investigate. Now, they can either do that themselves, or they can hire an outside investigator to come and do the investigation. Depending on the situations, if it's a simple matter, oftentimes the company will do it themselves. If it's a more complicated matter, they'll bring someone from the outside to do it. Now, what happens during the investigation is whoever is investigating is going to talk to people that have information. They're going to talk to everyone involved and get their opinion and perspective on what actually happened. So they'll talk to as many people as possible. They may have information to get everyone's position. And then, of course, the investigator is going to have to make some determinations as to what actually happened based on everything that they've learned. So ultimately, they may find that there was a poison work environment. Then the company has to fix it. They have to deal with that. Maybe that means punishing someone that's guilty. Maybe that means relocating someone. Maybe it simply means better training. If, of course, they determine for sure that there's no harassment, that they won't do anything. If you're part of an investigation, provide all the information that you have. Be honest. If you lie during an investigation, that's a very bad thing, okay? So, and that's all you need to do. If you're penalized at any point, you call me, and you call me right away. Okay, employmentlawyer.ca to connect with me, if that ever happens. So, Sir S, hopefully that answers your question. Any follow-up, you know what to do. You can ask it right now. Again, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP, answering your questions live. Bunch of questions here to answer. I'm going to get to them right now. Liz McGee, I have been off on sick leave. Doctor note agrees going back is good. Now my employer, 6 weeks later, still not putting me to work. HR doesn't respond. Okay, so they have to. And if they don't respond, if you've communicated with them, if you've tried and they just are ignoring you, a couple of things. Number one, that could be a human rights violation. If they're not bringing you back because you had a medical condition, that's illegal. That's a human rights violation. And certainly it's a constructive dismissal. If you can work and your employer won't put you to work, that's a constructive dismissal. It's illegal. So the key here, of course, Liz, is that you've tried to reach out to them in writing, because you don't want them to say, oh, no, you never called us. We never got any message from you. So in writing, email or text message, email works really well. If you have done that in writing and they've ignored you, it's time to get me involved. By me getting involved, there's two things I can do. Either I can pursue a case for human rights and constructive dismissal, or I can simply send them a letter saying, respond to Liz. Once I send them that letter, see how quickly they respond to you. Either way, I can help. So to connect with me, Liz, you need to do that now. Employmentlawyer.ca. Again, employmentlawyer.ca. So hopefully that makes sense, Liz. If I've missed something or something is not clear, ask a follow-up question. I'm here. Plenty of time still to do that. All right. Thank you for that question. Let's continue. Lucian. If WSIB does not want to send me a reason for not paying me, not even the resolution, can you ask for me why? Well, generally they will tell you. It may just take some time. If you're having problems with WSIB, connect with me off air. I'll give you the contact information for a very close colleague that deals exclusively with WSIB. He's probably the best in the province, and I can connect you with him. His name is Paul, and he'll be able to help you. So, Lucian, if you're having problems with WSIB, connect with me through employmentlawyer.ca, and I'll give you that contact information. All right, let's see. Next question comes to us from Neil. Neil asks, is an email saying that I agreed upon a severance amount enough to confirm I have accepted the terms of a severance? I made a mistake saying I agreed in an email and still want to speak with a lawyer. I haven't officially signed any documents. So if the company says in order to accept, you have to sign, by you sending an email, you haven't actually accepted. But here's what I would do to be sure. I would send them an email right now saying, I have not actually accepted the severance. I sent that email by mistake. I have not accepted. That's why I haven't signed the document and given to you. I'll respond back to you as soon as I can. So send that email. It's just 1 or 2 lines. And then, yes, you can call my office so we can do this properly. All right. But you have to do this right now. Send that email now. Okay. And then call my office right away. And to connect with me in my office, my team, easy, employmentlawyer.ca, right there, employmentlawyer.ca. That's the way to do that. Great questions today, guys. I'm really happy that you guys are asking me these great questions, things that you need to know, such important things. But if you're watching and you haven't asked your question yet, what are you waiting for? Easy to do, right? Ask that question. Let's talk about it. Let's make sure. Maybe something you've always wondered. Hey, I always assumed that, that's the law, but are you right? Are you not? Ask the question, I'll tell you. All right, continuing to answer questions. Stephen M., his question. What if your employer fires you because you are close to retirement age? What are your rights options to a compensation package? Well, your employer can never let you go because of your age. Age cannot be a factor, any factor, in deciding to let you go. So if the company has 3, 5, 10 reasons to let you go, even if one of those reasons is your age, it's not the only reason, but it's just one of the reasons, it's illegal. It's a human rights violation. It's age discrimination, right? Cannot happen ever, ever, ever. Now, remember, we don't have mandatory retirement anymore. We used to have it in Canada years and years ago. That's gone. So you can work till 65, 75, 95. It's up to you, the employee. The company can't tell you when you're going to retire, that you have to retire. Even suggesting to you that you should retire is in itself a problem and probably illegal. Okay, so you cannot be let go because they think you want to retire or they think you should retire. Illegal. Now, of course, you're going to be owed severance if you're let go, but because it's a human rights violation, you're going to be owed additional damages as well. And of course, remember, the older you are, the more severance is owed to you. So, Stephen, if your employer let you go because of your age, man, you got to call me, and you got to call me now, okay? Illegal, can't do that. And to connect with me, of course, employmentlawyer.ca and employmentlawyer.ca. Let's see here. By the way, I mentioned severance just a moment ago, and the fact that your age, the older you are, means you get more severance. I always get the question, you guys probably heard me talk about it. Well, how do I know how much severance I'm owed? What severance am I getting? How do I calculate that severance? Well, I'm going to tell you right now how to find out how much severance you are owed. Whether you lost your job, whether you're about to lose your job, maybe you're not, but you're just curious to know what you could be owed. Here's what you do. You go to pocketemploymentlawyer.ca. Good timing. Look at that thing right there, the address, pocketemploymentlawyer.ca. And when you go there, ta-da, severance calculator right there. When you click on that severance calculator, you can find out in a few seconds how much you are owed. You're going to answer a few questions, your age, your position, and the length of your employment. You'll just pick the answers from a drop-down menu, and you hit enter, and it's going to tell you how many months of severance you are owed. It's completely anonymous. It's completely free. You don't have to put in your name or the company's name. It's just there for you. It's the first place you go to if you lose your job. Remember, 90% of times when you lose your job, 90%, that severance offer is not even close to being appropriate. It's a lot less than what you're actually owed. How do you find out right away before you even call me? Again, use your severance calculator, go to pocketemploymentlawyer.ca, use that calculator, and you'll find out what the right amount is. So check it out right now or after this session or anytime you need to know how much severance you're owed. All right, I'm Lior Samfiru, of course, the employment lawyer with Samfiru, Tumarkin, LLP. I'm here live answering questions. I'm going to continue answering questions right now. But you got some time. You got about 10 minutes or so. Don't wait till the last minute because I'll miss that question if it comes in at the end. Still got some time. Answer or ask your question, and I'll tell you. All right, to next question. Sam has an interesting question, I think. I'm usually not a casual viewer of this type of content, but that term poisoned environment seems like a buzzword. Are there any good ways to understand what that type of system entails? So it's actually not a buzzword. It's a term that's used by our courts. So a poison work environment is a situation where if an objective person looked at it, they would consider that situation to be inappropriate or that environment to be unwelcome. It's as simple as that. An employer has a very strict legal obligation to foster a healthy and a supportive work environment. If they don't, and that environment becomes poison, that's a problem. Could be a violation of several statutes. It could be a constructive dismissal. It could be a human rights violation. It could be an occupational health and safety violation. You name it, it's not legal. So it's not just a buzzword. It's a real thing that our courts have recognized. All right, let's see. Continue to answer questions. Questions are coming in. Keep them coming in, guys. What are you waiting for? Let's do it. Sarah asks, do you have any legal options if you feel you were pressured to accept a severance package? I was berated by the supervisor and told it was good as I was going to get, it was as good as I was going to get, and any pushback would lead to a negative reference. This doesn't seem legal to me. Well, here's the thing. I get emails like this every single day, and I hate getting emails like that because the answer generally is once you sign, there's no going back. I understand the pressure. I understand the fear and the intimidation. You lost your job. You feel threatened. I get that 100%. But the law generally says if you ultimately make the decision to sign, we're going to hold you to it. There's really no way around it. Now, if you had something in writing to show that your employer said that if you don't sign, they'll badmouth you, maybe then you can show that threat. But they'll not admit it. So generally speaking, you cannot sign that severance offer. Here's the thing. Chances are, whatever you've been offered, even if the company tells you it's a great offer, chances are that it's not a great offer. It's a terrible offer. And the reason why there's a deadline is because they want you to sign it before you find out it's a terrible offer. It's as simple as that. So it doesn't matter if you work for a big company or a small company. It doesn't matter if you work for 2 months or 25 years. Don't sign it. As simple as that. Nothing bad will happen. Okay? Call me, call my office. If you don't like me, call another employment lawyer. That's fine. But do the right thing. If you lose that job, you have to get legal advice. Usually the difference between what you were offered and what you're actually owed can be tens of thousands of dollars. Sometimes it can be hundreds of thousands of dollars. Okay, so please do the right thing, do the smart thing. Don't sign it. And if you did, unfortunately, in most cases, there's nothing that can be done. Okay, so don't let that happen to you. Great question. Thank you for that answer, or I'll answer. How about we leave the answering to me? You ask the questions, and I'll answer them. We still have some time. Next question is from Bren. How long is an employer allowed to place you on a layoff for? That's a great question, and the answer is they're not allowed to place you on a temporary layoff at all. So I get asked often, well, I've been on a layoff for this amount of time. How long can I be on a layoff? You cannot be on a layoff. In most cases, an employer does not have a right to put you on a temporary layoff. And what I mean by that is if you're put on a temporary layoff, you can choose to treat that as a termination of your employment. You can choose to say, by putting me on that layoff, okay, you've now terminated my employment. You've now done something you're not allowed to do. Let me explain why that is. If I told you that your employer is reducing your pay by 50%, by half, you would know right away, right, that that's illegal. There's no way your employer can just reduce your pay by 50%, right? Absolutely, they can't. Well, what's a temporary layoff? A temporary layoff is reducing your pay by 100%. So it's absolutely illegal. So, Bren, if you've been put on a temporary layoff, let's talk about it. All right, let's make sure that you don't just sit at home and wait. And the problem is this: you may say, "Well, I really want to go back to work." That's fine. So you wait, and maybe in a few months they call you back. The problem with that is by accepting the layoff and going back to work, you've now given the company the right to do it again. So they didn't have a right to do it to begin with, but because you accepted it, now you've given them the right to do it again and again and again. Obviously, that's a big problem. It's not something you want to do. So that's why I say, please, 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 if you put on a temporary layoff, we should at least have the discussion about saying that's a constructive dismissal. So Brent, for you and anyone else in that situation, to connect with me right there, employmentlawyer.ca. Phone number is going to be found there. Email address is going to be found there. It's all there. So thank you for that, Brent. Great question, and hopefully that explains everything. Okay, Let's see. Sunny in Ontario, what's legally required for an executive's communication with their employer during sick leave in terms of method and frequency? What could be the repercussions if these requirements aren't adhered to? So generally speaking, there's no legal requirement. There's nothing specific that says by law you have to communicate with your employer once a week, twice a week. Here's what I say. First of all, obviously, you need a doctor's note to be off work. If it's going to be an extended leave of absence, I say at least once a month. Send an email to your employer telling them, employer, I'm still working on getting better, and I'll give you an update when I have it. Just that one line, once a month. The reason you're doing that is because you want to remind your employer that you're there, and you don't want them to think that because you've been gone so long that you've given up on going back to work, that you've decided to retire or to resign. You want to make sure that they understand that you're still working on getting back, because then they have to, when you're ready to come back to work, they have to make all efforts to bring you back. So there's no law that says you have to do what I just said, but it's a very good idea to do that. And by doing that, you're preserving your rights. So Sunny, hopefully that explains it. Let me know if it doesn't, but that's exactly what you should be doing. Thank you for that question. Let's see if we can get one more or so in. Next question from IMJ. It says, Mr. Lior, just Lior is fine. Been following your channel. Okay. And I'm very helpful, even though I'm in Quebec and a unionized employee. Can you please recommend any colleagues in Quebec to discuss my matter? Unfortunately, if you're a unionized employee, only the union can help you. So there's no one that I can recommend to you, because only the union is allowed to help you. So you have to speak with your union. So generally speaking, everything you hear me say today or in any one of my sessions does not apply to unionized employees. It only applies to non-union employees. Unionized employees have different rights. They're in the collective agreement, and the only one that can help enforce those is the union. You can't hire a lawyer. Okay. You know what? Let's take one more here. OB has a question. What should your next steps be if your employer is saying a doctor's note is no longer good enough to provide accommodations? They are asking for a more detailed explanation from your doctor. Well, if they have specific questions for your doctor, they can ask and you can give them the answer. If they want to know, has your condition changed, or how long are you going to need accommodation for, or is another job available, or is another job going to be good for you? They can ask those questions. That's legitimate, and you can give the answers. But what they can't do is say, well, we want to know what your medical condition is. We want to know what medication you're taking. We want to know what treatment you're getting. That's offside. They cannot ask that. All right. So if they have questions about your accommodation and what more they can be doing or should be doing, absolutely. They give you the questions. You can take it to your doctor and give them answers. But they can't say, well, we don't buy this anymore. We're going to stop accommodating you. Absolutely not. Remember, the obligation to accommodate is extremely important. If you need modified duties or modified hours, etc., and you have a doctor's note that says you need that, your company has to do whatever it needs to make it happen. Even if it's not easy to do, even if it costs them some money to do it, they have to do it. We have human rights laws that make that a requirement. So hopefully that helps, OB. Any other follow-up questions? Because we're coming to the end of the session, I want you to connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Guys, this is the time that we have for today. Again, thank you so much for joining me. Always a pleasure to be here, to talk to you, to answer questions. Some terrific questions today. I hope you learned a lot about employment law and your workplace rights. But remember, just because I'm turning off this session doesn't mean I'm going anywhere. Doesn't mean that my team across Canada is going anywhere. We're still here to help you. If you need us, easy, go to employmentlawyer.ca. Don't wait till the next time you see me on here. Let's connect today, tomorrow, whenever you need us. Okay, employmentlawyer.ca. Again, I'm Lior Samfiru with Samfiru Tumarkin LLP. They call me the employment lawyer. Thank you for joining me today, guys. We'll talk to you all again soon. Bye now.